Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk about the Suze Orman DIY Your Own Wills or Trust. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. Okay, so I've had now several clients come into my office when we are set to talk about their estate plan and possibly revisiting it. And they've either brought with me a executed Suze Orman plan that they downloaded off the internet and completed that they say is their existing estate plan, or one that they have just in draft form, but they've never completed it and they just wanted to kind of have me take a look at it, and so that way they know whether or not they can proceed with it, or if they should hire me or somebody else like me to help them put in place a more appropriate Florida-based plan. And so one of the things that I will say about these DIY download packages is first check the law, which is the governing law of the document. What I noticed about the Suze Orman package in particular is that the governing law in the document said it was California. We are based in Florida. Florida has very different laws than California, particularly when it comes to homestead protection. So the DIY package from the Suze Orman download does not adequately address or does not appropriately address Florida homestead. In fact, it uses California laws, which are different, and you might now lose your homestead protection because your documents don't provide that you're looking for the constitutional protections that are provided in Florida as to your homestead. So that was one thing that I thought was quite alarming, because most people's home is their greatest asset, and you would want to take advantage of our homestead protection under the Constitution so you can avoid creditor claims. And so things can pass, free and clear that way. Another thing that I noticed is that the way that the document is to be executed, the folks that came in and had it already signed and they thought that they had their plan in place with this package, they did not do the signing appropriately, meaning they didn't have the requisite witnesses and notary, and it wasn't signed in the appropriate manner such that that the will could be self-proving, meaning that if they were to pass away and that will was submitted to probate, we would need to find those witnesses that signed and have them go to the clerk of court and sign an oath. And many times witnesses are hard to track down. I've had to track down a few witnesses in my day. Many times they were retired secretaries from different law firms, or from attorneys that dabbled in wills and didn't really do wills full time, and so there was a little bit of mistakes in them and such that it wasn't self-proving. I had to track them down in the retirement home in North Carolina. Luckily, we were able to find them, but it was a little bit of a hassle, and it caused, a month or two delay, because we had to find these people, get them the oath, have it administered, have it admitted into probate. And so you don't really want to have to track down your witnesses. You'd prefer your will to be self-proving. Another one was just not properly witnessed at all, which means if you don't have two witnesses in Florida, you don't really have a valid will. So that was a problem in the sense that they didn't execute it properly. So there's a lot of ways to go wrong using these DIY kits. And the trouble with it is that you're gone, right? When we present these documents to court, you're gone. There's no fixing it now. So essentially, if you failed to properly execute or otherwise have some major blunders in your plan, that's it, right? There's no redos after you pass away, and your family is sitting there with documents what they believe is your wishes, right? And people get emotional about it. Not only do they lose you, but then people get just attached to what they believe is going to be their inheritance. And then we have to be the bearer of bad news and say that this is an ineffective document, and now we're going to go with the rules of intestacy, which might be very different than what you had put in your DIY plan. So all of this to say, you can be a penny wise and a pound foolish. Save yourself the $199 on those DIY kits and invest in help by somebody who can actually put an appropriate plan in place that you know will work. So that's my take on these DIY kits. Proceed with caution. Understand that you know there are many things that you may not realize that are being overlooked in these kits, or just not provided for. Okay, so if you have any other questions, feel free to drop me a comment. I hope that this information has been helpful. And as always, you can schedule a free strategy session with me at eldermeeting.com. Thanks for joining me.